The day my daughter slid those papers across the kitchen table, my kitchen table, the one her mother and I bought at an estate sale in 1987, I didn't raise my voice. I didn't cry. I picked up the documents, read every line, set them back down, and said, "I'll need to make a phone call." She thought I meant a doctor. She thought I was confused. I was calling my attorney. I'm 67 years old. I spent 31 years building a commercial real estate business from nothing. Started with one strip mall in Dayton, Ohio, ended up with a portfolio that stretched across 4 states. I retired 2 years ago when my wife, Eleanor, passed away from pancreatic cancer. 9 months from diagnosis to gone. That's all we got. After she died, I rattled around in our house in Columbus. 4 bedrooms, 3 acres, the kind of house you fill with grandchildren on holidays. I had the grandchildren. I had the holidays. What I didn't have anymore was Eleanor. And without her, the house felt like a museum dedicated to a life I used to live. My daughter, Renee. No, my daughter's name isn't in this story. She doesn't deserve the space. I'll call her what she became. My daughter. She called me every Sunday for the first 6 months after her mother died. Every Sunday, right at noon, she'd ask how I was eating, whether I'd been to the cardiologist, whether I needed anything. I thought she was grieving too. I thought we were grieving together. I should have paid closer attention to the questions she was asking. Dad, have you thought about what you're doing with the Dayton property? Dad, are you still managing all those accounts yourself? Dad, don't you think it would make sense to simplify things? I'd answer and change the subject. I'm not a man who discusses his finances over the phone on a Sunday afternoon. That's not how I was raised, and it's not how I ran my business. Her husband, I'll call him my son-in-law, because that's all he ever was, worked in financial planning. Mid-level. The kind of guy who talks about market trends at Thanksgiving dinner while his father-in-law, who has actually moved markets, tries to eat his turkey in peace. He had an opinion about everything and expertise in nothing, and my daughter had been married to him long enough that she'd started to sound just like him. They lived 40 minutes away in a house I helped them buy. Not gave helped. I co-signed the mortgage when they were short on credit history, and I wrote a check for the down payment that I told them was a gift, because I didn't want to spend the rest of my life watching them resent a debt. That was 11 years ago. They had never once mentioned it, which was fine. That's what parents do. What parents don't do. What I never imagined doing to my own father is file for legal guardianship of a person who is perfectly sound of mind. But I'm getting ahead of myself. It started, as these things often do, with something that seemed reasonable on the surface. My son-in-law suggested I consolidate my investment accounts under one management firm. His firm, he'd waive the advisory fees for family, he said. It would be simpler, he said. I was 65 and recently widowed and maybe not thinking as clearly as I used to. He implied not in those words. But the implication was there in the pauses, in the way he and my daughter exchanged glances when they thought I wasn't looking. I said I'd think about it. I had no intention of thinking about it. 2 weeks later, my daughter called to tell me she was worried. Not about my finances, about me. She'd been talking to a doctor, not my doctor, a doctor she'd found somewhere. And this doctor had mentioned that grief can sometimes accelerate cognitive decline in older adults. She was only bringing it up because she loved me. She wanted me to see someone. I made an appointment with my own physician, Dr. Kellerman, who has known me for 19 years. He ran every test available. His professional assessment, delivered with some amusement, was that I was one of the sharpest patients he'd seen all month. I did not share these results with my daughter immediately. I filed them away. That was the moment I understood what was happening. Not a suspicion anymore, a certainty. I called my attorney, a man named Ellis Pruitt, who had handled my business contracts for over 2 decades. I told him what was occurring. He listened without interrupting. When I finished, he said, "All right, let's start building a record." So I did, and I said nothing. The Thanksgiving that followed was the worst day of my adult life, and I have buried a wife, so that is not a statement I make lightly. They came for dinner, my daughter, my son-in-law, and their 2 kids, who are genuinely good children and know nothing of what their parents are. My daughter had apparently decided that subtlety was taking too long. She arrived with a manila folder. After the dishes were cleared while the kids were in the other room watching football, she placed the folder on the table. Inside were two documents. The first was a voluntary asset management agreement, a form that would transfer oversight of my investment portfolio to my son-in-law's firm. The second was a petition for limited guardianship, citing documented concerns about my cognitive health. Documented. By the unnamed doctor my daughter had consulted without my knowledge, who had never examined me, never met me, never spoken to me. I sat very still. I looked at the folder. I looked at my daughter, who was gripping her water glass with both hands. I looked at my son-in-law, who had the particular expression of a man who has rehearsed this scene many times and is pleased with how it's going. "I'll need to make a phone call," I said. My daughter reached across the table and put her hand on mine. "Dad, we're doing this because we care about you. You've been alone for 2 years. You're not sleeping well. You've lost weight. We just want to make sure someone is looking out for you. Some, as in them, as in my son-in-law's hands on my assets." "Give me a few minutes," I said. I went to the study. I called Ellis. He answered on the second ring. I had warned him this conversation might be coming over the holidays. "They moved," I said. "How bad?" "Guardianship petition, asset transfer agreement. The doctor they used is someone they sourced themselves." There was a pause. Then Ellis said, "Good. We're ready." What my daughter did not know was that 3 months earlier I had quietly restructured my estate. My properties were now held in an irrevocable trust. My liquid assets were distributed across accounts she had no knowledge of. I had undergone a formal cognitive evaluation, the full battery, administered by a neuropsychologist at Ohio State, not a walk-in clinic, and those results were notarized and on file with my attorney. And every conversation I'd had with my daughter and son-in-law in the preceding 4 months had been documented. Dates, topics, exact phrasing of their questions. I wasn't surprised. I was prepared. I walked back into the dining room. My son-in-law was refilling his wine. My daughter looked up when I came in, hopeful, like she thought I'd come back to sign. "I've spoken with my attorney," I said. "He advises me not to sign anything this evening." My son-in-law set down the bottle. "We're not trying to make this adversarial, Harv. I didn't ask for your input," I said. Not unkindly, just clearly. My daughter's face changed then. The concern fell away, and underneath it was something I hadn't seen before, not in her, not directed at me. Frustration, yes, but also calculation. It lasted only a second before she composed herself, but I saw it, and I didn't forget it. "Dad," she said, "if you don't let us help you, we're going to have to take this to the courts. We have a doctor's assessment. You have an opinion from someone who has never examined me," I said. "I have a full neuropsychological evaluation from a board-certified specialist. I also have 19 years of clean cognitive health records from my primary physician, and I have an attorney who has already prepared a response to any petition you intend to file." The room was very quiet. My son-in-law looked at my daughter. She looked at him. Then she looked at me, and I could see her recalibrating. Not retreating, not yet, but adjusting. "We'll be in touch," she said. "I know you will," I said. "Drive safe. The kids can stay if they want." The kids stayed. We watched the rest of the game. I made them hot chocolate. When their parents came back to pick them up 3 hours later, my daughter barely looked at me. My son-in-law shook my hand, which I found remarkable. I stood in the doorway and watched their taillights disappear down the driveway, and I thought about Eleanor and about how she had always said my daughter took after her grandfather, stubborn in the wrong ways, certain she was right even when the evidence was in front of her. Eleanor had loved her fiercely and clearly. I missed Eleanor's clarity more than I can say. The petition was filed in January. Ellis had told me to expect it. But there is a difference between expecting something and having it arrive in your mailbox on a gray Tuesday in January when you are 67 years old and you have done nothing wrong. The petition alleged that I was showing signs of cognitive impairment, that I had made erratic financial decisions in the preceding year, and that I was vulnerable to exploitation. The irony of that last phrase, given its source, was not lost on me. I did not respond emotionally. I had promised Ellis I wouldn't, and I kept that promise. What I did instead was make a list. Every financial decision I had made in the previous 3 years, every property transaction, every investment adjustment, every charitable gift. Beside each entry, I noted the rationale, not because I owed anyone a rationale, but because I wanted the record to be airtight. Ellis reviewed the list and said it was the most organized document a client had ever handed him. The hearing was scheduled for March. In February, my son-in-law did something I had not anticipated. He contacted my business partner, a man named Doug, who had worked with me for 18 years and remained a close friend after I retired. My son-in-law called Doug out of nowhere to ask whether he had noticed any changes in me over the past year. He framed it as concern. He was looking for corroboration. Doug called me the same afternoon. "Harvey," he said, "your son-in-law just called me fishing for dirt on you. I told him you were the same pain in the neck you've always been, and then I asked him not to call me again. I'm sending you the voicemail he left me, in case you need it." I sat with that for a long time. Not the phone call, the fact that my son-in-law had reached out to someone from my professional life, someone he barely knew, to build a case against me. That was not the act of a concerned family member. That was research. I forwarded the voicemail to Ellis. He added it to the file, which was getting heavy. The morning of the hearing, I wore the suit I'd worn to Eleanor's memorial service, not because I was mourning, because it was the suit I wore when I needed to be fully myself, and I needed to be fully myself that day. Ellis had prepared a response that was, in his own description, thorough. It included my cognitive evaluations, my medical records, Dr. Kellerman's written statement, the financial documentation of every major decision I'd made in the past 3 years, and a brief submitted by 2 of my former business partners, attesting to my acuity, judgment, and character. It also included a timeline of my daughter and son-in-law's escalating inquiries about my finances, beginning 11 months before the petition was filed. My daughter and son-in-law arrived at the courthouse with their attorney, a young man who looked like he'd graduated last spring. He was confident in the way that people are confident when they believe they hold a strong hand. He did not hold a strong hand. Within 45 minutes, the judge had reviewed Ellis's submission and the opposing documentation. She asked the unnamed doctor, who had, it emerged, conducted a 15-minute phone interview with my daughter and never spoken to me, to clarify the basis for his assessment. He could not do so satisfactorily. She then asked my son-in-law's attorney to explain what specific erratic financial decisions I had made. He cited the restructuring of my estate. The judge looked at him over her glasses. The petitioners are arguing that setting up an irrevocable trust is evidence of cognitive decline. In the context of other behavior, what other behavior, specifically? He did not have a specific answer. The petition was dismissed. The judge's ruling noted that the evidence presented by the petitioners was insufficient and that the cognitive assessment they had relied upon did not meet the standard required for guardianship proceedings. She did not editorialize further, but she didn't have to. The dismissal was complete. My daughter did not look at me as we left the courtroom. My son-in-law put his hand on her back and steered her toward the elevator. I watched them go. I felt something I hadn't expected, not satisfaction, not vindication, just a deep and settling exhaustion, like a door finally closing after years of cold air coming through the gap. Ellis put his hand on my shoulder in the hallway. "That's it," he said. "For now," I said. He nodded. He knew what I meant. What happened next was not revenge. I want to be clear about that, because I am not a man who operates from revenge. What happened next was consequence, which is a different thing. I had always intended to leave the house in Columbus to my daughter. It was in my original estate plan, drawn up years ago, and I had not changed it yet because some part of me had been waiting to see what she would do. Now I knew. I revised my will in April. The house will go to a charitable foundation I endowed in Eleanor's name, an organization that funds hospice care in Central Ohio, because that is where Eleanor spent her last weeks, and where strangers were kinder to her than her own daughter was to me. My liquid assets are distributed among my grandchildren, in trust, to be administered by Doug until each of them turns 25. They will have access to funds for education and medical needs in the meantime. My daughter will receive a single sum, the exact amount I contributed to her down payment in 2013, adjusted for inflation. A return of what was always hers, nothing more. I did not tell her. I don't intend to. In May, I sold the last remaining piece of commercial property in my portfolio, a warehouse space in Dayton I'd held onto for sentimental reasons because it was the first building I ever bought back in '98, old and terrified and certain I was making a mistake. I sold it to a young developer who reminded me of myself at that age, serious, slightly nervous, more capable than he believed. I gave him a fair price. The check was the largest single amount I had ever held in my hands. I sat with it for a while in the parking lot of Ellis's office before I deposited it. 35 years of work, reduced to a number on a piece of paper. Eleanor would have said something funny about that. She always could find the absurdity in things that made me solemn. I miss that about her most, I think. Not the grand gestures, not the long marriage, but the small comedy of being known by someone who sees you clearly. I drive out to Dayton sometimes, past the old warehouse. There's scaffolding on it now. The developer is converting it to mixed-use residential, ground floor retail, apartments above. He sent me the rendering. It looks nothing like what it was, which I think is the point of most things worth preserving. My grandchildren came for the 4th of July. We grilled in the backyard, and my grandson, who is 14 and deeply unimpressed by most things, asked me if I'd ever been scared in my life. I told him yes, twice. When I started the business and when his grandmother got sick. He nodded like that was a serious answer and went back to his corn. He's going to be okay, that kid. They both are. I still live in the house. People ask if I've thought about downsizing, and I tell them I'm already exactly the size I need to be. The garden Eleanor planted is coming in better this year than it has in years. I don't know anything about gardening, but I've been paying attention, and it turns out that's most of it. My daughter called once, in June. I let it go to voicemail. She said she hoped I was doing well and that she thought we should talk. She didn't say about what. She didn't apologize. I listened to the message twice and then I deleted it. There's nothing left to say that hasn't already been said in a courtroom, in a filing, in a judge's dismissal, in the silence that followed. I survived. I didn't just survive, I made sure of it. And on the days when the house is quiet and the garden is green and the light comes through the kitchen window at the angle, Eleanor always called her favorite time of day. I think that's enough. It's more than enough.